Hey, this is Gary Berger of Berger Law, and we're doing our weekly Ask a Lawyer show. I have decided to move it outside a little bit today, um, uh, just to change it up a little bit. Again, Gary Berger, Berger Law, doing our Ask a Lawyer show. We've been doing this now during the pandemic to get the word out and people's to get the word out to answer people's legal questions that they might have. So, without further ado, let's talk a little bit about this week in the legal news and what's going on. The Supreme Court, the United States Supreme Court, handed down two decisions this week, affirming that same that gay LGBTQ people were covered under for federal employment discrimination laws prohibiting discrimination on the basis of sex, which is a strong ruling by the court. Some of the conservative judges maybe went away, took a direction that may not have been anticipated. And there's been a lot of news this week for that. And also, the Supreme Court this week said that the way the Trump administration had tried to circumvent the the DACA rules of law about keeping children of immigrants in the United States was improper. I expect the Trump administration to attack that yet again in a different method, but the way they did was deemed improper by the court with some dissents. I think the gay rights case was a 6-3 decision, as I recall. So you got to remember, though, that so there are federal and state discrimination laws. In most places, you can fire someone for a good reason, a bad reason, or no reason at all. But you can't violate a federal anti-discrimination statute, which prevents people from being discriminated against because of their color, their age, their sex, and various other factors. Those are the main ones. And so the court said that, although not originally named in the statute, sex and sexual orientation was part of sex in a pretty strongly worded decision. So that was interesting. Got a lot of press, and that is on the right side of history in my view, and the way the law is going. That was the situation in Missouri too, but courts have interpreted these to say that if the motivating factor is someone's sexual orientation, that's the same thing as sex. I think a decision that'll be well supported and not significantly challenged going on in the future. Also with this being kind of the middle of June, we're changing our show. We're going to redo this show a little bit, switch it to Wednesdays. So the next show will be on July 1st to lead off the second half of the year. It'll be Wednesdays at 3 o'clock, so we'll have new notifications on for that as well. And just to, these times are when sometimes you sit back and take stock of how the first half of the year has gone. And in terms of me and the firm and the Berger Law Firm and the clients that we serve, we've had a fantastic year. We have been, even with this crazy corona and the crazy pandemic and how it has changed life and changed business as we know it, we have filed more lawsuits, settled more cases, gotten more justice for folks. We haven't tried cases because we're not trying cases now, but in terms of that, we're just hitting on all fours. So as a personal matter, as a time to reflect and sit back and take stock in accomplishments and plan for the second half of the year, it's been a good year to help the clients and the many people we serve. We've done a lot of work, even though there is this strange pandemic time that we're in. We're also, this week marks the first full week that we're back to work at our physical location in downtown St. Louis. We have other satellite offices. We are doing staggered shifts, so everybody's working 2 days a week. We're staggering stuff. We're separating people physically. We're doing social distancing. We're cleaning workstations. We have new sets of rules. Our building owner has been great about complying with CEC and city and state guidelines, city guidelines rather. So that's been great. I got a new haircut, the number 6. I gave myself another haircut, I call it the number 6, because I'm not going to the usual hair people and I'm just shaving it like all my military friends. They're like, yeah, I've been doing that for years. Who cares? So, so, so a lot of things in the news. It's as you know, our gay and lesbian friends and colleagues. I've just seen all over Facebook and talking to them, so overjoyed. Of course, it's the right decision, but so overjoyed with the Supreme Court decision, and so that was great. So let me move on now. So let's ask a lawyer. So what does that mean in discrimination? Well, that means that if you're fired because you're gay, or then you can't be. That you have a federal discrimination claim, and also state in Missouri and Illinois too. So what happens if you're fired and you think that the reason really was because of your sexual orientation? You file a charge of discrimination with the Equal Employment Opportunity Commission, or the Missouri Commission on Human Rights, or the Illinois Commission on Human Rights within 180 days of your adverse employment action or employment separation, and that's how you preserve your rights to make an employment discrimination claim. You can't, it's not illegal for an employer to be a jerk. But if they're a jerk because of your age or your sex or your race, then that is discriminatory and actionable legally. And those could be tough laws. The jury instructions are clear. The succeeding party gets attorney's fees. If you succeed, I've gotten attorney's fees in cases. You can't discriminate against on basis of pregnancy also. So those can be successful cases. If you go to my website, we have a lot of successes in those. So that's fantastic. We still have not gotten a decision in the Department of Corrections case. I know that we have our Department of Corrections friends who regularly ask me about that. So just to let everybody know that that's the case, or not the case, so to speak. And I am wearing my shark bow tie today. So I got done. I had a 3-hour Zoom continuing legal education class that me and 2 other lawyer friends of mine taught to about 100 other lawyers today about liens and negotiating and resolving liens in cases. And we get a lot of lien questions. So what a lien is, and people have been asking me this today, so to answer that question is a lien is when someone else claims an interest in a case. So a medical provider, a health insurance is paid benefits. If you get benefits under workers' compensation, or Medicaid or Medicare, they can claim a lien in your personal injury case. So if you get in a car wreck and you get medical care and you settle with the other side, sometimes the person who provided the medical care wants to get paid from that case. And there's a Missouri statute, Illinois statutes in various states that enable that to happen. There's also limitations. We use the Missouri lien reduction statute effectively where you can reduce liens for claimants. The similar true is if the health insurance company pays the medical in the case, they can assert a lien. The health insurance company can assert a lien to get paid back. If it's a state claim, they don't have a right to do so. But if they're an ERISA claim, they do. And ERISA is the Employment Retirement Income Security Act of 1974. So liens are a big part of cases these days, because not only do we, and if you're representing an injured person, not only do you try to get as much money in the front end of the case to settle or resolve the case, you try to reduce the payout to the lien holders or the other people on the back end so that our clients get as much money in their pocket as we can. And liens are a big part of these cases because everybody wants their money back these days, and we get lien holders asserting these liens from all corners. So my presentation was that. I've taught this for years. If you Google in St. Louis, if you Google how to resolve liens in personal injury cases, my white paper on that is the first top Google result that shows up, because I've been writing and talking about this for years. There's a lot of techniques that we use that we've innovated with to try to get the best result for our clients we can. That doesn't mean that you don't treat the lien holder or the provider fairly, because our clients get a lot of benefit from the medical providers. There's great surgeons and great nurses and great chiropractors and physical therapists that give great assistance and support to our clients. We want to make sure they get paid, but we don't want them to get overpaid, no disrespect. And there's other factors that can come in. What if you have $1 million in damages, but the insurance policy is only $100,000? Well, everybody's got to take a haircut or take a reduction, and the lien holder should take that as well. I have various other strategies that I use that I taught about 100 lawyers about today. And so I just thought I'd just start with a couple answers and questions about liens and whether you have to pay liens and pay bills out. Because one of the things we try to do in our cases is make sure that when our clients are done with the case, they don't have anybody coming after them for money. So one of the services we provide and have always provided is we settle and resolve those cases. We protect our clients from those bills in terms of writing letters of protection during the pendency of the case, but we also try to resolve and reduce those as much as we can at the end of the case. So I see some other questions coming up on our feed here. And I answered so many questions today on Zoom. I feel that I've been doing this a lot today, but it's great. And if you ever want, to our viewers, if you ever want answers to these legal questions, we have a lawyer versus lawyer page or a lawyer referral page. We do CLEs, continuing legal education, or education classes for lawyers, where we answer a lot of high-end lawyer questions, which is also happen to be the high-end questions we get from our clients. So a lot of times people can look, this is Ask a Lawyer program. A lot of people can look for their answers to their questions on that page on our website, and we have those. I mean, I do presentations on immunity, liens, trying cases, taking depositions, ethics, all kinds of stuff. Today it was on ERISA, liens, as well as an ethics. So a friend of mine and I did a long thing about legal ethics, decreasing stress, mindfulness, meditation, addiction and alcoholism, etc. I'm on the Supreme Court Intervention Committee, which is a group of lawyers that help the Supreme Court and the bar and other lawyers with mental health, stress, depression, and addiction problems. Danielle, moving on. Danielle asks, my friend was recently laid off from her job due to COVID-19 but was denied unemployment. Can a lawyer help her appeal her unemployment claim? Yes, they can, Danielle. So what your friend should do is immediately appeal the denial of the unemployment. Unemployment can only be denied if there is misconduct or inappropriate conduct in connection with the work she was doing. So if she was just straight up laid off, she should be getting unemployment. Now they have requirements. You got to, try to go look for jobs. You can't just sit on your laurels. You can't have stolen money from your company and gotten unemployment. But if you're laid off in this corona epidemic, you should be getting unemployment. And if you're denied, you can file an appeal, because they make it so that you can file an appeal, or Google unemployment benefit denial lawyers. If you Google unemployment benefit lawyers or unemployment denial benefit lawyers, you can do that. There's a lot of lawyers that do it. I've done it for friends. I do it for current clients. I'm not in the business of doing that kind of stuff. But basically hire a lawyer to go in, look at the statute, and you can Google it yourself. Look at, self-help. Look yourself about the grounds on which an employer can validly deny unemployment, and that should inform you of how you argue that the benefits were wrongfully denied. Everybody should be getting unemployment now. It's a terrible economic time, and we need to support those who've been separated from their employment because of that. So we have a question. Laura says she loves my bow tie. Thank you. You know what the great thing about in 2 days is? It's Father's Day. And I know I'm going to get more great ties. So I know this is one of my shark ties. Apparently, as a plaintiff's lawyer, apparently people think they should get me shark ties. I don't know where that comes from. But I'm going to get more ties on Sunday. I'm so excited. I hit reply. Thanks, Laura. So I got another question. So if I could go back to that question. Cancel that. So, great. So I have another question. Hold on. I lost my, here we go. Sorry, Here I am trying to do technology and I'm trying to chew gum and walk at the same time. D- Uh, uh, Here's a question. My dad hurt his back on the job years ago falling off a ladder, I think more than five. His job never filed an accident claim, and he was able to continue working afterwards, but he is no longer working for that company. He is considering filing for disability now because of his pain. Do you think he could or even would like be able to sue his old company for the work accident? No. So in a word, no. Now, let's talk a little bit more about the issues that you raise in your good question. So the time limit to file a claim for compensation in Missouri is either 2 or 3 years. The time to file a claim for compensation in Illinois is only 2 years. In Missouri, it's 2 years but if the employer never filed a report of injury, it's 3 years. So if there's been no claim for compensation filed, you cannot recover. And people think sometimes that just because I got hurt on the job, I automatically have a claim filed. That's not true. You do not automatically have a claim filed. Your employer may have filed a report of injury, and they're required to if they have 6 or more employees, but they may not have. So, and the claim for compensation is not going to negatively affect your right to get your medical care, your right to get paid temporary total disability while you're off. However, at the end of a workers' compensation claim, you're entitled to a lump sum disability settlement at the end of the case, which is what we do. We take it, we charge 25% for those like everybody does. We don't charge on the TTD or the other claim. So you missed that time. Your father missed that time. I'm very sorry. Now, and a lot of employers don't file accident claims. And there's really not a lot of teeth in that law because they'll say, hey, we really didn't know he was hurt, or they'll make some kind of an excuse. Now, he can still, though, file for disability. So he can file for Social Security disability with the federal government. They will deny it the first time. They always do. If you ever get denied for Social Security on your first time, don't stress it. That's very typical. But he can file for disability and start getting payments now. Hopefully, all your father's medical was paid for his back injury. So there you go. So we have a current ladder case in litigation now. I've had a lot of ladder cases. Those can be very dangerous. So I wish him the very best. The good news is that, for instance, Social Security work comp won't have any lien in the Social Security recovery. You'll have to worry about that. I mean, that's a silver lining, I know, but I spent a lot of time today talking to lawyers and teaching them about workers' compensation liens. So workers' compensation, if you're paid workers' compensation benefits in the case, they can turn around and try to get their money back out of a civil claim, and that's governed by Missouri Statute 287.150, or an old case called Rudiger. It's called the Rudiger formula. So there you go. All right. Adam Houston, good to see you. Adam, how are you? Why don't some courtrooms allow video recording during a trial? Well, that is a great question. So what they are balancing is the First Amendment right to free press and freedom of speech, plus the right to which is the First Amendment in the U.S. Constitution, or the First Amendment and the Bill of Rights. The Seventh Amendment to the Bill of Rights is the right to trial by jury. You need to balance those two rights, and you don't want to have video footage of evidence in a courtroom that may sway the jurors when they watch the news at night. You don't want the jurors to hear out of court statements. So what happens in a courtroom, everything that happens in a courtroom doesn't go to the jury. The judge makes evidentiary rulings. The judge makes other rulings on the propriety or the appropriateness for a jury to hear evidence or hear lawyers' arguments. Maybe a lawyer saying stuff that the judge told him, you can't say that to a jury. There are rules about evidence. There's relevancy. There's hearsay. There is foundation. A lawyer just can't come in and start, or a person can't just come in and saying whatever they want in a courtroom. We have rules about reliability so that we have the judge and the court system acts as gatekeeping procedures to make sure that the jury only hears fair evidence, fair to both sides. And there's rules about collateral source. For instance, if I sue a defendant, I can't go in and say the defendant who I'm suing in a car crash case is really represented by an insurance company. It's not just a poor little old lady who rear-ended my client. She's represented by a huge insurance company with billions of assets, and she's got $1 million policy. So give my client $1 million. I'm not allowed to say that. Similarly, the defendant can't come in and say things about my client that aren't appropriate. So if a camera was in the courtroom, they would pick that up and broadcast that. So the court, I think most of the time, appropriately balances the right of press to be in a hearing with the protecting the jury and protecting the judicial system. I was on a hearing where press is going to be there just last week. I have press cover things. Press can interview you later. Press can interview jurors. Press can interview lawyers. We talked last week, I think either one time ago or 2 times ago on the show, I mentioned there's ethics rules about press, guarding against press. Lawyers cannot and should not try their case in the press before that, try to influence a jury. Why do we still have those people that sketch in a courtroom? Brennan asked. That's mostly to support artists. Aren't those the worst? Sometimes they're work. Hey, guess what? So for Father's Day, I just was handed this cookie. So I get a cookie for Father's Day, a little bit early present. Isn't this good? Oh, this is from Colleen's. They're really good. If you want a good restaurant, now we don't have a giveaway this week because we're reorienting our talk show and our giveaways to local businesses. But if you want to go to a great local business, go to Colleen's. I think it's on Forsyth, right over there just east of Clayton. They have great food. And I'm going to taste one of their cookies right now. I get the quiche there. It's awesome. This cookie is outstanding. Let me go to, well, Brennan asked the same question. Seriously, about the sketch artists in the courtroom. That's because they don't want live video. And so the sketch artist is able to show a little bit about what it looks like going on. Bernard Wilson asked me what's going on with the overtime pay for the Missouri corrections officers. That case is still pending before the Missouri Supreme Court. They have not rendered a decision yet, and we do not know when that decision is going to come down. So we look forward to seeing a victory in that case and getting justice for the thousands of corrections officers that it has been my sincere privilege to represent for 8 years now. This case started in 2012. It's 2020. Let me continue down. The courthouse in Columbia, Missouri does not allow anyone to bring in a cell phone when they enter. It has to do with taking video. If I have I can take my phone if I have a bar card, because I have my bar card and I'm an officer of the court because I'm a lawyer. So I can do that. But you record things. You record things will be taken out of context. People have, in courtrooms, people have attorney-client privilege communications that someone could pick up. The court can protect the identity of victims of different crimes. They can protect an accused in a criminal matter. I was just talking civil before, but they can protect an accused. You're innocent until you're proven guilty. So they can protect an innocent person's reputation. Sometimes someone's arrested for something. You don't want a picture of yourself in an orange jumpsuit in shackles in a courtroom when you may beat those charges, and that would be inappropriate. So there are regulations about that. Don McClure is my friend Don McClure. If you ever want a great lawyer down in Houston, Texas, Don is great. And I love, Don, seeing you and your wife's Facebook posts and stuff. Don does some great shows, social media shows, a great Friday newsletter, does some great stuff down there. He helps a lot of people down there. Adam asks me, I hear a lot about business interruption lately, but a denied BI claim sees destined for drawn-out lawsuits and appeals before any settlement or an insurance payment might be paid out, if at all. What is a business owner supposed to do between now and then, and how do they afford legal representation? So I know I can talk a lot, but let me zone in and answer the question. I'm a lawyer. What am I supposed to do, right? Let me answer the questions, yeses and nos, because I hate it when politicians never answer a question, which we're about to get more and more of that. So here we go. What is a business owner supposed to do between now and then? You're going to suffer the loss. I was just sent a private message. Let me come back for a minute. I went last night and ate at Counterculture off Watson Road. And let me give another plug for them. My friend Chris Meyer, who owns and runs it, just sent me a message saying, thanks for chatting last night. We gave out a $150 gift certificate last week to that. What a great restaurant, great food, good, hard-working South City people. Go to Kitchen Culture, go to Counterculture, folks. I had this ramen and egg thing where they put the ramen noodles and the egg together and they fry it up or cook it, and it's just so good. Great tofu, great food, very popular. A business owner with a business interruption claim, you're just out of the money. You can't force an insurance company to pay you before you win the case. So you're out the money between now and then. May it be protracted litigation? Maybe, if they force you to trial, yes. However, a lot of the facts are not disputed in those cases. So what we do in these cases is we file a lawsuit. One is for a declaratory judgment action, and then we can file summary judgment motions. We can expedite these things to try to get paid quickly. And that's what our goal is to do, always, is to get paid quickly for our clients, because we know our clients are out the money. And every way that we can to speed up the litigation in that process, we will. We don't sit for 6 months and file a lawsuit. We're going to get the lawsuit on file. We're going to push it. How do they afford legal representation was your second question, Adam. I represent people on a contingency fee basis. What that means is they don't pay me by the hour. They pay me a percentage of what I get for them. If I don't win their case, they don't pay me anything, and I eat the expenses. If I win the case, they pay me the percentage, and they pay me the expenses I front on their behalf. It's only expenses that I front, checks that I actually write out of my own pocket for records, filing fees, experts, et cetera, et cetera. We put a lot of money and time into these, both into these cases. I put a lot of money and time into the Missouri Department of Corrections case that it gets asked about and was just asked about. Let me keep going in my questions here. Maya asks me, with COVID-19 affecting so many people's lives in so many ways, the recent demonstrations and events taking place all over the country, and the summer season coming up, how do you as an attorney balance your family life and personal time with your workload? That's a great question. I do not always wear nice ties and suits. So I try to be conscious and present in all that I do. I was just at a seminar today about mindfulness and being conscious and present. So I try to live the serenity prayer. God, grant me the things I cannot change. God, grant me the wisdom to know that God, no, I'm getting the serenity prayer wrong. But you want to be conscious and present in all your time. You don't want to worry too much about things you cannot change. You want to understand the difference between what you can change and what you can't change. And you want to be mindful and deal with your stress. So I have a very busy life. I have a family that I hang out with. I have a vibrant practice. I have a lot of hobbies. Tomorrow I'm going to go scuba diving all day. 2 days ago I was working with my bees. I dropped my kid off at daycare. I picked him up. My family's behind me right now. I'm about to go swim with them. I'm going to have dinner tonight with them. I just kind of I work and hang out with my family. That's what I like to do when I do that. God grant me the serenity to accept the things I cannot change, the courage to change the things I can and the wisdom to know the difference from my mind error a minute ago. So that's how I deal with the stress of that. And then, but that we talk about as lawyers. I did a CLE for an hour today about work-life balance and doing it, especially when you're working from home. I work at night a lot because I want to be present with my family when I'm with them. Taking a couple hours out doing that. I don't know. It's everybody's got to work on that balance. But the great thing, Maya, is that you're asking about it. The great thing is we're talking about it on this show. What happens to people and lawyers is you isolate yourselves. You don't think you think you're the only one who's got these problems. You self-isolate. Getting out and talking to other lawyers, bouncing stuff, figuring out that we're all going through the same stress in life, learning that we're all, as humans, we're all the same. The same stress and depression that I get or anxiety that I get, and I manage all those things well. Everybody gets it. Everybody gets it. If you ever have talks with good friends about that, then they all get it. And I'm don't have a lot of that these days. I haven't for a long time. But you have bouts in your life where you deal with that. So focusing on your gratitude, having a life of gratitude, getting out there, getting out of your own way, doing that thing to balance it. Do what you enjoy doing. Those are all some little tools that I do. So that answers your question. Probably too deeper than you wanted me to answer it. Thank you. I see some people commenting. They've looked in on CaseNet, no decisions. You're welcome, Michael. You're welcome, Bernard. Happy to help you. Kira asks me, what state should I find an attorney in for a car wreck? Where I live, where it happened, where the other person lives, are all in different states. I literally am filing a lawsuit about that now. I do it all the time. I was talking to my client Linda in Tennessee. Accident happened here. So what you want to do is you can sue someone at the location where the car wreck happened or where the defendant lived. Because if there's a truck driver from Pennsylvania coming through here and crashes on 40, 70, or 44, or wherever, 55, they've subjected themselves to jurisdiction in the state of Missouri because they committed a tortious act here. And for instance, so I can sue them here. I can also go to their home state of Pennsylvania or wherever I said they were from, and I can sue them there too. Usually we sue them here because we don't want to go get hometowned in their backyard or anything like that. Not that that happens. I mean, it can happen, but look, people mete out justice everywhere. I go all over the place. I'm filing a document in a case we filed in Utah right now. Yesterday I was in a court hearing in a case we filed in Kansas City. We're over in Illinois. I've been an Illinois lawyer for 27 years, so we go all over the place. But now the one thing though is you got to remember is if you file suit in state court and the citizens in this between the plaintiff and the defendant are from two different states, the defendant can remove the case to federal court, and we have defendants who do that. So then they take the case out of the jurisdiction of the state court and bring it to federal court. Why do defendants do that? They do that for a couple of reasons. Sometimes we were talking about gatekeeping for evidence getting in, and sometimes the gatekeeping for experts, letting expert testimony in is stronger and more preventative in federal court and state court, although that changed in Missouri with the adoption of the same federal standard a couple of years ago. In federal court, you need a unanimous jury. In Illinois, Missouri, and most other states, you need 9 of 12, so you don't need a unanimous jury. Not that we don't mind persuading everybody, but you can have one person in a jury that tries to hold the damages low, sometimes because of the evidence of the facts, sometimes because of a political bent or view. And so we want to try to avoid that because my job is to get full compensation for my clients, not 80% or 50% compensation. So sometimes they think that. Now, I have mental cases in federal court. I've tried them there. I've been successful there, but that's just the deal. Thanks, Diane, for putting Counterculture's website in our comments section. That was very kind of you. Thank you. Here's a question from David. When is it needed to bring in another lawyer on a case? What generally prompts having to have multiple attorneys instead of just one? And is that normal only for a big federal state or simple cases like a car crash case? So that's a good question. So In my Utah case, I have local counsel because I'm not a member of the Utah bar. So I have a local counsel who's a great guy, by the way. I really like him, Brett. And I file a motion for admission pro hoc vice, or this case only, a Latin thing for pro hoc vice, and I get admitted into that. And I get admitted, and then I go and I can try the case and litigate the case there. So if I'm asked to come in and represent someone, or if I have a friend or someone and they're in another state, I need to file a suit there, and they're in a court of jurisdiction that I'm not licensed in. That's how that works. Sometimes lawyers team up in big cases where you want to spread the risk and spread the work. And I rarely do that, but I've done that a few times in my career, probably 5, less than 10. Sometimes people come in and ask me to come in if into a case, other lawyers ask me to come in to co-counsel with them where they're a divorce lawyer or a business lawyer or a trust and estates lawyer, or they're not a PI lawyer, but their friend or longtime client gets injured, and they ask me to come in. They represent them too, but I come in because I have more expertise in that area. I try cases in those areas, and I think sometimes your name, you get a little bit of a reputation when you do it for a little while. So sometimes I can effectuate a better settlement and a better result too. So that can happen too. So sometimes other lawyers ask me to come in and assist them in cases. Sometimes it's real complex. Sometimes it's a med mal case with real complex issues, and it's just not something another lawyer wants to take on. Or they take it on for a while, and then the defendant has a heavy-handed defense strategy. They're doing a scorched earth deal, and they need some more power behind them to help them, and I'm happy to do it. I guess asked in. When that happens, when lawyers co-counsel together, the question is also that I see is, how does that affect the fee? Doesn't affect the fee. So if someone signs a contingency fee with a lawyer, and the lawyer asks me to come in, that lawyer and I share the fee. So you can hear this bird, this beautiful bird here. That's kind of nice. We have I put out a lot of bird seed, and we track a lot of birds in our yard, which is always fun this time of year. It's a great time of year. The big nectar flow for bees. The birds are happy. The moles in my yard are happy apparently because my dogs are digging them up everywhere and going crazy all night. So that's basically that. David, it's in the more complicated cases where a lawyer like me may be asked to come in. So there you go. But there are arcane areas of law like ERISA or other things where sometimes someone else may come in. Rodney asked me, we got a lot of questions. I got to move along, okay? I got to move along so everybody can go to their weekend. I appreciate everybody watching. Can an otherly abled person sue if they are injured on a non-ADA compliant properties accommodations? Yes, you can. Rod, good question. So if a person has some type of otherly abled or the American with Disabilities Act still protects them, and that would be a dangerous condition of property. So it's a dangerous condition of property. If someone has a ramp that breaks or a ramp that has a gap where a wheelchair can't get over or doesn't appropriately accommodate under the ADA, that's a good case, Rod. And there are strict, that may even be a better case because, the ADA has strict guidelines and requirements and standards on how those types of things are supposed to be built. Burger Law, yes, thank you. I know I mind blanked on the Serenity Prayer. I've said it 1,000 times, so thanks for posting it. But that's the idea of surrender and acceptance and not stressing out about things you can't control. I see that was posted by David on our feed because apparently I forgot it. Jeez Louise. That's a real thing. And you know what? So the other thing about this, managing your stress and surrender, remember that just because you have clarity and serenity one day doesn't mean you have it the next day. So one of the things about humans is we go in and out of clarity. That's why you have prayer. That's why you have meditation. You don't just pray once and then you're done for the next 60 years. You don't just meditate once and then you're done. You do this on a daily basis or a regular basis to maintain your mental health. So that's why you say the serenity prayer over and over again, because you got to remind yourself. You're like, oh shit, I'm worried about this, that, or the other thing. I'm worried about my job next week. I'm worried about, I think it may be drizzling now. I'm worried about my job. I'm worried about my kids. I'm worried about my work. I'm worried about my health. I'm worried all the crap that keeps us up at night. The monkey. Oh, my kids are squirting water at me. Somebody is. My daughter is. Hi, Audrey. I'm gonna put her on the camera. You can see her. They're messing with me. There they are. So you got to remember to remind yourself of that stuff. You know, you need the constant reminders. That's the way the brain works. That's the way our monkey caveman brains work, is that you need the reminder. You need to remind yourself of your surrender. You need to remind yourself of that clarity. That's why you say, God grant me the serenity to accept the things I cannot change, the courage to change the things I can, and the wisdom to know the difference. There's another great prayer. It's called Acceptance is the Answer to All My Problems Today, which is my favorite. I have it on my phone. I always have it on my phone, because you need to, whenever God or somebody or your higher power throws something in your way, that's the way your life is supposed to be that way. And acceptance of that and surrender to the life that you have been dealt, and then take the next step. What is showing up for you in that obstacle that's been thrown in your way? That's where the rubber hits the road about being a human and working on those things. Next question. Are you going to swim in the suit? Is that your bathing suit? No, I'm not going to swim in this. Although I will tell you, my kids always push me in with my clothes on. I've been doing this since my 15-year-old was a little kid. So I'll put on shorts and a t-shirt or shoes or come in for a run or ride. And the joke is that they push me in my clothes, and I make sure I know I don't have my phone on and all that stuff on me. So I will probably go put on something else. But I have a 2-year-old son who's about the cutest thing you've ever seen. And I'll go down there and we'll say, hey, do you want to push me in? And he'll get out and he'll go push me in. And then he'll think it's hilarious. And I do can openers and stuff, but he doesn't call them can openers and stuff. He doesn't call them cannonballs. He calls them meatballs. So we say, hey, you want me to do a meatball? So even though I don't eat meat. How many bow ties do you own? I'm about to own 2 more bow ties on Father's Day in 2 days, because I'm probably going to get more. I probably own 20 of them or something like that. I wear them, I kind of like bow ties. They're kind of fun. They're kind of different. I tie my own bow ties. So, and if you don't believe me, I will tie a bow tie while I'm talking. Uh-oh, now I'm going to mess it up. I'm going to tie a bow tie while I talk to you. And it's reverse on this screen. So this is really tough because it's showing me reverse. So I started wearing bow ties about 10 or something years ago. Just something different rather than regular old ties all the time. It's kind of boring. And I do them. I like them. Sometimes you could think, oh, that guy's a persnickety guy or stuff, but that's not it. It's just something different. You can tie them and make them look good. So there's a bow tie for you. I'm not worried. It's opposite. So there you go. So that's how you tie a bow tie. If you ever want to tie a bow tie, there's people do it on YouTube, and I just watched a YouTube video and did it in a mirror over and over and over, and so I got it right. Oh, I went the wrong way on this thing. So there you go. All right. So there's my bow tie. All right. If someone wrecks my website, would that be a claim for eligible for damages? If someone wrecks your website, call Orange Design or go to orangedesign.com, because they will build you a website that you do not have to have wrecked. Orange Design is my website, people, and they're amazing, amazing SEO firm, local firm. They're the firm that other people hire to get the real work done. But yeah, Brennan. So there's a tort claim called tortious interference with a business relationship. So if well, I don't know if that would apply. Yeah, I mean, wrecking your website, Brennan, is the same as going down these days. The same. It's property damage. Now you need to find the IP address of who did it and find out who did it. And you need to find them. You need to sue them. Insurance is not going to cover them, so you're going to have to hire a lawyer to sue them, get a judgment, collect against them personally. Brennan, and the people at Orange Design know more than me how hard it is to find that IP address and who really is behind that. But we have that. I mean, not wrecking websites, but I have people, putting up putting up ads if someone searches my name, or there's all kinds of hanky panky that can go on in the competitive world. But it's an unfair trade practice, so it's an unfair practice, and it's also you can also have there's a consumer law in Missouri called the Merchandising Practices Act. It's called the MMPA because it's the Missouri Merchandising Practices Act, and that it's a pretty powerful tool. So if that's an unfair consumer practice or an unfair trade practice, there are both federal and state laws to protect that. So that would maybe answer Brennan's question. And my buddy David just put up a note. So anybody who's following this or later or whatnot, we're gonna move our show to Wednesdays at 3 because on Fridays I have my family wanting to swim with me, and we're gonna keep this as a regular show. We were doing this more because of COVID and try to reach out to people and answer people's questions. We're having fun with it, and I think I'm maybe getting better at it. I mean, I'm not as choppy as before. I don't. So there you go. And you know what David did? He put up the whole prayer, the whole Serenity Prayer, living one day at a time, enjoying one moment at a time, accepting hardship as a pathway to peace. That's a great. Thank you. I appreciate that, David. It's a good reminder for Friday. Well, everybody, listen. I can't think of any more great questions to answer. I want to check one thing while I'm still talking to you. That's all I got. There's some other questions I had seen, but I think I touched on enough today. I gave a lot of content out today, talked about a lot of different stuff. Hey, folks, if there's any questions that anybody has that I didn't answer or any issues that come up, people say, "Oh, I answer your questions for free." No, you don't really. Well, actually, we do. All right. So I'm not just saying that. I always answer people's questions for free. If you have a case or a legal issue, call me and I evaluate it for you. I've been doing it for a long time. I do it really easily. It's kind of my strong suit. So I can analyze this stuff quick. I can tell you the deal, meaning I can tell you what your legal rights are, the likelihood of success, what the pluses and minuses are, what your legal pitfalls are. I can rattle that stuff off really quickly, especially if I've been drinking coffee all day like I am now. I can talk real fast and I can do it real fast. And that's one of the reasons why I do what I do, is to raise all boats and help all the people. The more you give, the more you get in life. And since we're getting deep here and talking about stress and stuff. And so if I'm able to give away stuff to people, I get more out of it than I ever do. Any volunteer work I do, any work that I do with other lawyers, any work I do for the Supreme Court Intervention Committee or any other stuff I do, the more I give, the more I get so much more out of helping people. And if you ever talk to people who really spend a lot, and I'm not getting on my high horse here because I don't do nearly the kind of pro bono and volunteer work that other people I know do. There are some people who are darn saints for doing all the work they do. I do a little bit. But if you ever talk to people who really spend a lot of time giving that away, the serenity that radiates from those people when you talk to them is astounding. You're like, wow, I want to be like that dude. All right. Thanks, everybody. Have any questions? Like I said, I'll answer questions. Email me at gary@burgerlaw.com. Call us at 866-599-2222, 314-542-2222, 816-277-2222. Find us at burgerlaw.com. Thanks, everybody. Have a great weekend.